Awesome. Welcome to Co-op-Palooza Week. Our goal this week is to raise $20,000 by Friday to support our work democratizing workplaces everywhere. All month long, we've been sharing stories, resources, and new ideas from the members of our labor team. This event is how to pay ourselves equitably in search of a salary calculator for social justice. We want to give a shout out to our Co-op-Palooza Week sponsors. They helped us make it such that we can host 7 events this week. You can check out the rest of our calendar on the slides that Mwenda will share right now. It's a folder with slides and paperwork for MCLE documentation if you are a California lawyer. So
I'm so sorry to interrupt. I'm one of the interpreters. Did we have a deaf participant in this call?
We do not. We're just making sure that the recording has ASL interpretation.
Oh, okay. I arrived late because I was having some tech issues. But let me. I'm so sorry. Go ahead.
Can you? No. What is your name?
My name is Daisy Moore.
Thank you.
Awesome. And would Daisy like to go first, or would Betty like to go first?
I had already started, unless Daisy, did you all start?
I'm so sorry. I was having some tech problems. I'm so sorry to interrupt. I'll let Betty go ahead and I'll come back in between. So sorry.
Okay.
All right, Mwenda, is Betty spotlit?
Yes.
All right. Okay, thank you. So this is our agenda for today. My coworkers and I are going to go over some example salary calculators that we use here at the Law Center. Then we'll have a guest speaker, Kiki Counsel, who will go over federal civil rights and employment laws. My coworker Hope will then go over the California versions of those laws that apply to these calculators. And then our guest speaker, Shirley McLaughlin, will talk about some special rules that apply specifically to nonprofit organizations who are interested in adopting needs-based calculators or reparations calculators. Hopefully we'll have time at the end for some Q&A, but if we don't, then you're welcome to RSVP to our legal cafes, which we hold 3 times a month, and you can come with any legal questions you have. So the SELC panelists today are me, Alejandra, and Hope. I'm going to turn it over to them right now.
Hi, all. My name is Hope, and I am a legal apprentice and co-director at SELC's Radical Real Estate Law School. I'd like to first begin by acknowledging that the Sustainable Economies Law Center is on occupied Ohlone land. And just for now, setting this tone, we'll begin here. I love these cartoons. It's a brilliant visualization of capitalism. I like to think that the 1% is the person on the other side of that fence. So then we have equality, and equality means that each individual or group of people is given the same resources or boxes in this case, or opportunities, but that's still lacking. And then equity recognizes that each person has different circumstances and allocates the exact resources and opportunities needed to reach an equal outcome. It's kind of a holistic approach. And there is no justice under capitalism. Justice is fenceless, and it is what we are striving for. At SELC, we started off with an equal pay rate regardless of location, education, seniority, and needs. Now we take into account needs, and we're still in the stages of paying ourselves equitably. And so what might seem so inherent to us could be construed as radicals to others. And I'm excited to announce that we're now asking ourselves, as an organization in the movement for social justice, how do we protect ourselves from reverse discrimination lawsuits? It's exciting stuff. And so here are my thoughts. When I was asked to take our reparations adjustment survey, I felt ashamed, not deserving, even uncomfortable. Might just be an echo of the rippling effects of growing up in a capitalistic colonizing society. And it took me a long time in my life to be comfortable in my own skin. And in a way, I'm still healing from the effects of growing up in predominantly white spaces. And it wasn't until I spoke to my mentoring attorney, Tia, but I realized that this was a really important step to take, and reparations are not a radical idea. It's justice. So thank you.
Yeah, thanks, Hope. My name is Alejandra. I'm a staff attorney with the Law Center. I just wanted to speak on my experience with the wage calculator at the Law Center. First, I want to say that I am in awe of the way that the Law Center is so open and transparent about compensation. And we'll get more into what the salary calculator actually is and what it does. But before my start date, I met with one of my coworkers to discuss my salary. So my body was all tense. I was used to having to advocate for myself at this point in the process, which makes me uncomfortable for many reasons that I won't get into now. So when my coworker shared their screen and showed me everyone's salary in the spreadsheet, my body immediately relaxed. My focus that was like already on the power dynamic sort of melted away, and I just felt great about my decision to take the job. I saw that the fact that I have a daughter would be factored into my pay, and I would get some money toward her childcare. These two things really stood out to me and made me feel like this organization really tries to see you as a whole person. I also love that I wouldn't be paid more than non-attorney coworkers. As an attorney, that takes a lot of pressure off and gave me space to learn and grow into the role. I didn't feel like I had to know it all to justify making more than others. And it was a really liberating feeling after being so immersed in the toxic hierarchy of the legal profession. So there was nothing to negotiate, and that felt just so great. And I'll hand it back to Tia.
Thank you, Alejandra, for sharing and for Hope. Let's see. So we're going to start with an example of a salary calculator that is very similar to the one that we use at the Law Center. And this salary calculator first addresses the needs of each staff. So what the calculator does is it asks, for example, about each staff's person's childcare needs. How many children do you have that are in childcare? It asks the staff member about the number of dependents that they have, and this can be children or adult-aged dependents. This also asks how much money their dependents earn, if any, to account for that extra household income. Then the calculator asks whether someone like a partner is helping those dependents. If you are not presenting, can you please put yourself on mute? Or when you can mute people, that would be great. Awesome, thank you. Okay, so where was I? Just that this calculator also supports, it also asks whether someone like a partner is helping you support those dependents. And then it asks the county that you live in. And we ask about the county because we need to determine the area cost of basic needs for each staff member. And we do this by using the MIT Living Wage Calculator, where we pull the numbers for the cost of basic needs for one person, the cost of childcare, and the cost of supporting other humans. So here the bonus is just the cost of childcare plus the cost of having dependents, but you can change this up to suit your organization. By the way, these slides have the link to the actual calculator so that you can see the formulas and explanations more closely. Wenda will share a folder with the slides when she can in the chat, and we'll also email it out to you all. So one thing to note though is that the MIT Living Wage Calculator only gives the number for basic needs. It doesn't account for people's wants and savings. So one way to fix that, if your organization can afford to pay your staff more than the living wage, it's to figure out how much of one's salary should go to basic needs. Here we use a formula at the Law Center that would make it such that only 60% of a person's salary should be spent on basic needs. That leaves 40% for wants and savings. In other words, 60% of my salary should be able to cover my rent, my transportation needs, my healthcare, food, taxes, and then 40% can be used to put into savings or to put into other things that I want to support, like mutual aid efforts or local worker-owned cooperative cafes, or to invest in awesome things like the East Bay Permanent Real Estate Cooperative or the Segurity Land Trust. So I have 40% of my salary can go to anything I want, basically. So in the salary calculator in the spreadsheet, you can find this formula in the tab called MIT Living Wage plus wants and savings. So those are just the needs that we accounted for because it's what our coworkers wanted. But there are many other needs that you could add into your calculator. For example, the cost of elder care, student loan debt, medical debt, generational wealth. If you have any other ideas about needs that should go into a calculator at your workplace, please put it in the chat. One thing we've been talking about recently is retirement plan savings and other needs. So feel free to put it in the chat and we'll add it to the slide for everyone's consideration. So that's our calculator that only covers the basic needs of our coworkers. And right now I'm going to hand it over to Alejandra, my coworker, who will talk a little bit about something that I think is a little more interesting, which is the lowercase r reparations salary calculator adjustments. Go ahead, Alejandra.
Thank you, Tia. I was looking for my mute button. So what is a reparation salary adjustment? So I didn't know that when I came to the law center about a year ago. And my coworkers were at the tail end of a process to determine the form that the reparations adjustment, in quotes, would take. So money was set aside to pay folks according to what the group decided. There were several versions of the adjustment, including some that were very detailed and accounted for all types of socioeconomic disparities. And the collective decision-making process was working in that it was unearthing some tough emotions and differences of opinion in terms of approach. So my understanding was that at the core of all of the discussion was a strongly held value of being vigilant in addressing white supremacy, to look at ourselves and the culture that we are immersed in and to do something about it. So with that, I drafted the language that was adopted with the goal of capturing our intentions in simple terms while also avoiding unnecessary legal risk. So it was a start that we all felt good about, but it is still a work in progress. So the language that we settled on acknowledges the enduring damage caused by historical injustices in the US, including slavery, segregation, colonialism, and racial discrimination, and that the legacy of these injustices continues to have a disparate impact on our lives. What it doesn't do is it doesn't mention race or ethnicity, and it also is not capital R reparations for slavery, though we support reparations and will continue to support movements to win reparations. So a few other details that are important to mention are that we settled on a one-time adjustment. We included language to address how it fits into our tax exempt purposes. Specifically that retention of a diverse staff allows us to provide higher quality of educational materials and puts us in a better position to eliminate prejudice and discrimination. So we decided that everyone gets it. So you receive a Google form with the language that I've shared with you, and all you need to do is type in your name and press submit. But you can opt out for any reason. Maybe you feel that given your own experience of privilege, accepting the money wouldn't serve the purpose of addressing systemic oppression. And maybe it's complicated. So there is also an option to reduce the amount you receive by 50%. we put a note about our shared values and intentions in the language of the adjustment. So I'll read that. Our hope is that this material benefit will directly or indirectly touch the larger communities that bear the brunt of historical injustices and systemic oppression. So this was grounding for me because it reminded me of the role that I can play within a larger community to repair harm. I mentioned that this is a work in progress. So this webinar is a step in that direction. We're gathering more information about legal risk, paying attention to those guardrails, but also considering what other groups have come up with, like the idea of equitable merit compensation. And I can talk a little bit more about that. After attending a training by the team at Harmonize, I wanted to explore how we can use equitable merit compensation in our approach. It centers BIPOC workers with less legal risk because it focuses on the unique contributions brought by folks whose expertise is often undervalued by capitalist structures. For example, if you work for an organization that serves undocumented people and you are undocumented, equitable merit compensation would account for the clear fact that your contribution is especially valuable to the work of the organization. So it enables groups to distribute money to people who have been negatively impacted by systems of oppression and to pay people for the seen and unseen labor spent transforming those systems. And that really makes a lot of sense to me. So I'm looking forward to diving into that with my coworkers. So with that, I would like to introduce the next speaker, Kiki Council. Kiki is an amazing lawyer and activist. She received the Attorney of the Year Award from the Colorado LGBT Bar Association for her efforts in the racial justice movement, and her background is in labor and employment litigation. So thank you all so much.
Hi, everybody. My name is Kiki Council. I use she, her pronouns, and I'm here to rain on everybody's parade. Just kidding. I'm here to talk about how the federal law makes, ironically, stuff like this really difficult, and why it can be frustrating, but ways that we can all protect ourselves as we try to move towards more equitable payment to each other. So I am going to try to speak quickly. You all have access to these slides. I'm not going to try to read every single thing to you, and this is pretty dense. So if you do have questions as they come, please drop them in the chat so that we can try to get to them at the end. So I noticed a couple people in the chat talking about, why don't we base things on gender? Why don't we base pay calculators on gender? The big reason why that's probably not the best idea is because of the first federal act I'm going to talk about, which is the Equal Pay Act, also known as the EPA in the labor and employment world, of 1963. And basically what that does is prevents employers from discriminating on the basis of sex, any payment of wage to employees. And wages under the federal law does include bonuses. So that is really important to keep in mind. The entire analysis, which I'll get into further, is based on equal work that requires equal skill, effort, and responsibility for which those are performed. If we can go to the next slide. So important basic historical context for the EPA, which is really also feeds into the irony and kind of theme of all of what I'm about to talk to you about, is that the equal pay movement actually began with men. And that's because before World War II, women made up less than 25% of the workforce. That obviously changed pretty dramatically during World War II because women made up less, because women had traditionally been making less than men. That led male workers after World War II, after they came back to the United States, to be very concerned that their own wages would become depressed. So men actually started the movement for equal pay because women had been historically excluded from the workforce. We can go to the next slide. Efforts were made to codify the EPA in 1945, but that failed. The original language used comparable work. And there was a big kerfuffle over all that. We don't need to go through it. You can read about it on the EEOC website if you're interested in some nerdy law stuff. But almost 2 decades later, in the 60s, under the Kennedy administration, labor activist Esther Peterson submitted a draft of the EPA to Congress. The final iteration of the bill had changed comparable work to equal work, which is defined as jobs requiring equal skill, effort, and responsibility, which are performed under similar working conditions. So there are certain exemptions and risks, right, involved with the Equal Pay Act. So there are actual pay differentials that are allowed under the federal law between genders, and that's okay. Specifically when there's a seniority system, a merit system, a system which measures earning by quantity or quality of the production of work, or a differential based on any other factor than sex. In order to be successful, an employer has to show that the systems were put in place not as a way to discriminate. And the biggest risk in implementing something like a needs-based calculator, like we were all just discussing, is a reverse discrimination lawsuit under the EPA or under Title VII. Could we go to the next slide, please? So what are reverse discrimination cases? That sounds wild, doesn't it? Reverse discrimination cases are basically a case where an employee that is typically from a majority dominant or historically protected group alleges some form of discrimination by the employer in favor of the historical minority. So this would be a case where a white man would say, I am being historically discriminated, I'm being discriminated against based on my status as a white male. These laws weren't intended, obviously, to protect white men, except for they kind of were. Reverse discrimination cases are cases where it's not a woman bringing the violation of the act. It's not a person of color or BIPOC person bringing the violation of the act. It is somebody from a historically dominant group. These cases are very difficult to prove, which should reassure most of us, but according to some legal scholars, do appear to be increasing in frequency, which also probably shouldn't be very surprising given the current political climate. Next slide, please. So to be successful on these reverse discrimination cases, a plaintiff has to show that they're a member of a protected class. And so we're all members of protected class. Sex is a protected class, gender is a protected class, race is a protected class. Again, even if it's a race that has been historically included, such as Caucasian or white, or if it's somebody that has been historically excluded, such as an African-American or Black person, those are protected classes under the law. They also have to show that similarly situated employees outside of that class received more favorable treatment, that the information that supports the employer discriminating, or that there's information supporting that the employer discriminates against historically privileged or majority groups. And this is what's really hard, right? It's really, 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 really hard to prove that a employer historically favors Black women over white men. It's not to say that it's not possible. It certainly has happened before. There's certainly cases out there, but this is where a lot of reverse discrimination cases fail. And finally, the plaintiff has to show that they performed their job in a satisfactory manner, particularly if it's a part of a promotion decision. So would a court find, and this is the real question here, right? Would a court find that a needs-based calculator is a bona fide system under the EPA in a reverse discrimination case? And here is also my fun and most favorite thing to do on panels like this, and say, it depends. It totally depends. It's so hard to say. There is a risk for some employers implementing such a system because it's not primarily based on seniority, merit, or productivity. We're talking about, children. We're talking about medical debt. We're talking about taking care of people with disabilities. We're talking about the county that you live in. What if it's the case that you live in a county that's majority BIPOC and somebody else doesn't? Would that actually be discrimination? It's really hard to say. It's really hard to say. And this is a new and developing area of the law. We're kind of at the forefront in discussing these sorts of solutions for pay equity. So it's not a very comfortable answer, but you have to take that risk, I guess, in order to change the law, right? And we can talk a little bit more about those sort of strategies. But the real thing that we should all be focused on too is the fact that a system based on this predetermined criteria that is communicated to all employees does in fact weigh in the employer's favor. So that's really the key that we all have to focus on, right? We need to also make sure that there's no system in place that would allow a supervisor to arbitrarily authorize exemptions at their discretion. So it can't just be up to one manager to say, well, I feel like Kiki deserves more because she's a queer woman of color who lives in Denver, Colorado, where living costs are spiraling out of control. I'd love that. But it can't just be up to my boss to decide that for me. It has to be a uniform system. And that's why calculators that take independent factors into consideration are a really great idea. So as long as we talk to everybody about it, we evenly apply it, we should probably be okay. All right, so next slide. I'm sort of bouncing between these two and I'm sorry. Just trying to be mindful of time. Again, I apologize for speaking so quickly. So next slide after that, actually, please. All right, so what if there's no bona fide system in place? An employer can also attempt to show that there's other legitimate factors beyond gender that would justify the pay differential. But if we're at that point, we're already at the point where an employer has to rebut a presumption of discrimination. Next slide. So factors other than gender that are sufficient to rebut a claim of discrimination is that the factor is related to job requirements or beneficial to the employer's business. And again, all of these tests are based on so many cases and so many different analyses that we really don't, I could like write a book on this. We don't have time to talk about all of it. So keep that in mind, but these are just the basic framework that the factor is reasonable to further the employer's business or to some other employment practice, that it's applied to both male and female employees. And that's the difference here with the pay calculator. Everybody's subject to it no matter what. That the employer and employee are aware that the factor was or was not applied in setting the pay. So being able to articulate again to all employees, we're all doing this. It's happening for all of us. We're all getting our lives put into this calculator and that's how our pay is going to be put out. And the factors application is the reason for the difference in the pay. Next slide, please. So just some quick examples of valid factors include education, experience, training programs, working evenings or night shifts, or job applications and classifications. All right, next slide. So just to summarize for the EPA, these are some important notes to keep in mind. The EPA only applies to employers with more than 20 plus employees. But huge caveat, please check your state and local laws. I am based in Denver. I know a lot of people in here are based in California. California has some of the most complicated labor and employment schemes in the United States. It changes by municipality. Your overtime pay and calculations and meal and rest periods are different in San Francisco than they might be in LA. So while you might not have to comply with the EPA federally because you have less than 20 employees does not mean necessarily that you would not have to apply with state and local law. Number one. Number two, claims under the EPA are super, super rare. They're declining over time. There's usually less than 1,000 claims per year at the EEOC. Claims under the EPA have not been successful at equalizing the pay gap at all, which really sucks, but that's the truth of it all. And part of it might be because of the historical context that this was originally intended to make sure that men's pay stayed high. I don't know. Again, this is a topic for my future book, maybe. Thanks for everyone in the chat. And then lastly, never underestimate the possibility of a reverse discrimination claim. Even, though we should also understand that these claims are difficult to prove, especially when using a uniform system. So I'm going over my time to talk, so I'm going to try to blast so hard and fast through these Title VII slides. So when most of us think about labor and employment law, I think Title VII is most of what we are familiar with. It's a comprehensive set of federal laws that prohibit discrimination based on all the protected classes I talked about. The thing that we really have to keep in mind here is that compensation claims under Title VII are way more expansive than they are under the EPA, because those claims are not limited just to equal pay for equal work. The analysis focuses on similarly situated employees, so that opens the field up much more. It magnifies that legal risk. Next slide, please. So, let's see, sorry. Oh, the thing to know about Title VII, beyond it protecting you on certain protected classes, which is great, it also only applies to employers with more than 15 employees. So like the EPA, if you have less than 15 employees, you are not subject to this federal law. So that means you can kind of be a little bit experimental and think about what you're doing, because you're not subject to federal jurisdiction. But again, you may or may not still be subject to local and state law. All right, next slide, please. So the legal risk of a reparations adjustment, small r, there is a much higher risk of reverse discrimination claims due to the broader protections of Title VII. And when investigating non-base salary compensation, which is what a reparations adjustment would be, the EEOC focuses on whether the employer's policy is non-discriminatory in application and design. So there's basically two issues that an investigator will look at. And when you do an EEOC claim, you go to the, your state local office, you say, hey, being discriminated against, you check off your boxes, it goes to an investigator, and then they look into your claim before it actually goes anywhere. And what the investigators look at is how the employer applies the eligibility criteria to non-based compensation to persons both inside and outside of the protected class, and whether those eligible for the non-based compensation receive non-based compensation in non-discriminatory amounts. So what does all of that nonsense mean? Next slide, please. So this is basically it. Because the eligibility of reparations necessarily depends on a protected class and opting into that, the employer is at a legal risk of a Title VII violation. I think it would be disingenuous for most of us here in this sort of conversation to say that we would anticipate that white people or Caucasian people or people who haven't been historically excluded from certain spaces would opt into this adjustment at the same rate as BIPOC people, as queer people, as whoever, right? And in addition to that, because those who are not members of groups that might have been entitled to reparations receive no additional compensation, the employer is at legal risk, not as much, but the fact that the template offers employees the ability to opt in or out does mitigate some of that risk. So it does help. But we have to think about the general effect. The analysis is a little bit different under Title VII. We're thinking about similarly situated people. So all I want to say and close out on is that there is a high degree of irony that either or both the EPA or Title VII could be used to strike down efforts to level the playing field for women and Black folks or any other BIPOC or, again, historically excluded population. But it's a legal risk that must be accounted for and acknowledged. And again, a legal risk that we are uniquely positioned to take on and to try to create some good law, especially for those of you that live in California. Federally, the law tends to be much more favorable towards employees. Ninth Circuit tends to have much more liberal judges. If you're someplace like me in Colorado in the 10th Circuit, ooh, good luck. But again, this is a new area of law. And who knows, like I said earlier, claims at the EEOC generally for both the EPA and for Title VII are declining, though the reverse discrimination cases are rising. So all stuff to think about. Excited to answer your all's questions, and I really hope that I didn't cut too much into everybody else's in the Q&A time, but I'll also drop my email, and if you all have other questions, I'm more than happy to answer them in a general sense. I am not your attorney, but happy to be here and answer what I can. Thanks, everybody.
Excellent. Kiki, your life goals. It's really a pleasure being on this panel with you. I'm going to delve into California laws. Yep. So I had a lot of fun researching California employment law. I've got into the weeds a little bit, but like a lot. And so just what Kiki said, a lot of law nerd stuff. So I'll just give you the bird's eye view. In California, we have the Fair Employment and Housing Act and our version of the Equal Pay Act. The Fair Employment and Housing Act is housed under Government Code Section 12940A. And California's Equal Pay Act lives in the Labor Code Section 1197.5 and Labor Code Section 432.3. And we'll test you on that later. Next slide. So we're a heck of a lot stricter here in California. For example, as Kiki mentioned, Title VII of the Federal Civil Rights Act only applies to employers with 15 or more employees. And in California, the FEHA applies to employers with only 5 or more employees. Also, harassment is always illegal in California, even if an employer has less than 5 employees. In California, an employee must prove that they are being paid less than an employee of the opposite sex, of another race, or of another ethnicity who is performing substantially similar work. Once an employee makes this showing, the employer must then prove that it has a legitimate reason for the pay difference. So here, that's me, can SELC prove that it has a legitimate reason for the pay difference between myself and my coworker, Dorian? Dorian and I are both legal apprentices and we do substantially similar work. We are different genders and different races. My hourly rate is more than Dorian's because I live in San Francisco and Dorian lives in Oakland. And our needs-based calculator at the Law Center just recognizes that my cost of living is more expensive in San Francisco. So my salary is more than Dorian's. But like I explained earlier, the only thing Dorian needs to prove to bring a claim under California's EPA is that we do substantially similar work. We're different genders, races, and I get paid more than them. And again, similar to what Kiki explained for federal law in California, the Law Center would just have to prove that we have a legitimate reason for the pay difference. This hasn't been litigated yet, but we are prepared to argue, I am, that our needs-based calculator is a bona fide factor other than sex, race, and ethnicity. But how about our reparations adjustment? What I was talking about before. In part because of the reparations adjustment, I get paid more per hour than Janelle. But that's only because Janelle opted out of receiving the reparations adjustment. And we hope that this protects us and we think the risk is worth doing the right thing. And now I would like to introduce Shirley, our next speaker. She is an attorney at Adler & Colvin. She specializes in nonprofit and tax-exempt organizations, and for the last decade has worked with local community foundations, donors, and grant makers. She is an all-around fabulous person, so take it away, Shirley. Thank you.
Sure. Thanks, Hope. First of all, thanks everybody. I'm always really excited to participate with the Law Center's community of folks. So I'm happy to be here. Like Kiki, I am going to try to not be the downer on the panel. I really am gonna focus on additional limitations on charitable nonprofit organizations and the types of barriers they're facing to get to equitable pay and using calculators like we've been talking about today. This slide is my sources of hope. thank you, Hope, but this is a different kind of hope. I am really going to focus on these aspects of different types of laws that apply to charities. As we go through, you'll see these come back up, but these I think are the hooks to hang on to try to show that reparations pay, adjustments, different kinds of equitable compensation can work in a charitable context potentially. Next slide. So this is a highly regulated space. These are the things we're going to cover today. Definition of charitable, what are charitable trust restrictions, prohibitions on private benefit and inurement, and some excise tax issues. I'm going to jump actually back and forth between some federal and some state, some California law specifically. Other states, of course, have their own charitable regulations, but I'm going to focus on California and federal law here. These are like the major guardrails that we'll talk about. There are plenty of others actually, but I think these are the best ones to start with. Next. So we'll start with some very basic federal law on what defines charitable. This is directly from the tax regulations. So federal definition of charitable includes all of these activities. There are others also, but I wanted to focus on this space because it includes things like lessening neighborhood tensions, to eliminate prejudice and discrimination, to defend human and civil rights secured by law. There's a portion of the regulations that even say that, you know, advocating social or civic changes or presenting opinion on controversial issues with the intention of molding public opinion is acceptable. Those are all acceptable charitable purposes, and they are a reasonable basis for potentially different kinds of compensation, even within the charitable organization. So certainly an organization's outward activities can fit into these buckets, but its internal operations can also be consistent with these charitable purposes. The other thing I want to say about what's charitable is that it changes over time. It is not a completely static definition. So things like a couple of examples that aren't particularly in this space, but think about pharmaceuticals, for example. Some drugs that we've developed over time can be done in that development and research and even distribution of pharmaceuticals can be done in a charitable context, particularly where drug companies are not willing to step in because it's supporting a poor population, for example, who aren't going to be able to pay market prices for these drugs, things like that. So, but as a drug, you know, maybe gets onto market and is used in other ways, maybe it's no longer charitable to support research and development on that drug because now drug companies and other the capitalist system has really gotten involved and taken it away. So it can change over time, and I think it's a basis for everyone to be hopeful about what charitable can mean over time. I'm going to skip ahead. Next slide. This is a flip to state restrictions. So I want to talk just a little bit about charitable trust, what that means in California especially. A donor can make a contribution to a charity and put valid legal restrictions on that money. The legal restrictions can shift over time also, just like we talked about with the federal definition of charitable. So for example, there's a set of cases around a park in Georgia where a donor from their estate said, here's this parkland to the city in Georgia, and I only want it to be used for white people. Well, whether that's a valid legal restriction or not has changed over time, right? And the courts have had to adjust to those valid legal restrictions. Obviously, in this case, you know, it would be an interesting thought experiment to think through whether, you know, an organization, a charity had a donor who really wanted to contribute some funds to that charity and say, look, this should be used for staff compensation, and I want it to be distributed in a way that's equitable. And what would that mean, right? Would that be considered a valid legal restriction? I think it's an expansive definition that we could think through with litigation in the future potentially. I also wanted to say that under charitable trust restrictions in California, the restrictions don't only apply to contributions received, but also from any revenue generated within the organization and anything that that it accumulates over time. So even if it's not just a donor, if the organization has articles of incorporation that have specific purposes in it, those specific purposes apply to any money that the organization brings in. So it's really got to make sure that it's spending its money for these charitable purposes. In California, unless there's a binding obligation to pay, the payment of bonuses or retirement benefits by a charity to its employees can constitute an improper diversion of charitable assets. So there's a seminal case in this area, Queen of Angels versus Younger, for those law nerds that I've been seeing in the chat. It's a 1977 case. And it was, I don't want to go into too much detail, but it was basically a religious order of nuns and a hospital system. And they had been operating under certain assumptions for a long time. And then they decided to say, well, actually, all those services the nuns provided to the hospital in the past, they were unpaid and they need to be paid now. And the state of California said absolutely not. At the time, everybody agreed that those were donated services essentially, and to go back and pay them now when there was no binding obligation to pay would be a diversion of charitable assets. So I just want to focus on the fact that you can have a binding obligation to pay, right? This is one of those sources of hope. Set a plan in advance. You know, even if your organization is small, you don't have current funds to pay bonuses, to merit-based bonuses, to pay retirement plans. Set it up now so that you have that binding obligation in place. And then if your organization grows and you are able to fulfill those contribution requirements to a retirement plan, something like that, you'll have the binding obligation to pay in place. So just one strategy to think of. Next slide. I'm going to rush through a bunch of these. This is back to federal law a little bit. Charities are prohibited from providing inurement or too much private benefit. This is really focused on its insiders usually. So think people like directors, officers, highly paid employees. It can be a loose definition in some contexts. It can mean people with substantial influence. So maybe a founder, maybe somebody who is a major donor, maybe somebody who oversees a large portion of the budget, for example. It can also be any private individual out there if they're receiving more benefit than the organization is providing in charitable benefits to the public. So there are absolutely rules here. A charitable organization will not be considered meeting its charitable requirements to maintain its tax exempt status if it is providing inurement, basically distributing its profit to its insiders, or if it is providing too much private benefit to even its staff relative to its charitable benefits to the public. I think this is a really rich place for discussion, and I'd be happy to answer more questions about this, but I just wanted to mention that you know, every employee, by getting a salary, is getting some form of private benefit, but it's the fact that their pay is incidental and basically unavoidable in the organization carrying out its charitable purposes that makes that an incidental private benefit. It is a permissible private benefit. So when you're thinking about putting into place compensation systems, you'll want to make sure that those systems also match with your charitable purpose. And I remember I think Tia or Alejandra mentioning that when they were going through their values process, right, they were actually pointing to their charitable purpose when they were designing their system. And I think that's a really important thing to do. I want to go to the next slide quickly, because another way to make sure that you're protected from private inurement and private benefit is to make sure that you're providing reasonable compensation. Now, the definition of reasonable is really broad, but there are a couple of ways, especially for a public charity, to make sure that they are providing reasonable compensation. And there's actually a presumption that they can obtain that would favor them over the IRS if they were to step in and challenge the compensation structure. So obtaining, first of all, they've got to approve it in advance. The board has got to be involved, and the board has to approve the system in advance. So it's absolutely similar to what the other presenters have talked about, having a system, having a policy that's applied across the board. So approve it in advance, get the board involved. then make sure that you've got appropriate comparability data. So maybe that's using those calculators that are out there. Maybe it's using a compensation consultant, doing things and hiring experts, finding tools out there that the board can rely on is really important to this process. And then also making sure that that everybody is on the same page about how this works. Document it in policies, document the board decision, and make sure that that there's enough there to show that if the board was questioned about the decisions they made, that they did it with a reasonable basis. They relied on experts, they looked at comparability data. Next slide. I'm just going to spend my last couple of minutes because I know we want to leave some room for questions and a call to action. So my last slide is just a little bit of miscellaneous thoughts left over. Especially in California, there's a Nonprofit Integrity Act. Like the slide says, it's kind of seen as the Sarbanes-Oxley for nonprofits, a little bit of oversight. It, among other things, requires the full board to review and review the compensation for a CEO, a president, whoever's in that position, as well as a CFO, a treasurer, anybody who's sort of responsible for the finances of the organization. I'm advocating that the board should be involved for all of the compensation decisions at a certain point. Maybe for very large organizations that gets delegated a little bit, but certainly under the NIA, the board should be involved in at least those two positions. There's also this interesting requirement under California law that it's not in the law of many other states, but it requires that the board be made up of disinterested people, a majority of disinterested people. So I think this is an equity issue because if you are looking to have a board that is diverse, you might be looking to pay for their time. Right? It's an important function. You want people to be able to come and participate fully in your board meetings and you're thinking about compensating them. That's fine. Actually, you can compensate them in their capacity as directors. But if those people are also workers, they're also employees and getting compensated in other ways, then this limitation can come into play if you're compensating everyone or more than a majority of people. So it's an opportunity to look outside of California for corporate law, but probably not something that a lot of folks are going to run into. I just want to mention that there are some disclosure issues around compensation that everybody should be aware of for charities. There are tax returns and state filings that will ask questions about compensation policies and actually require disclosure of compensation in some cases. So just know that along with that last bullet point there around public scrutiny, even if a regulator isn't stepping in, know that there are people out there looking at tax returns and other kinds of public documentation for charities and looking for issues to bring up to the public. So keep that in mind. My last thought here is just that my goal is really to, make sure that people feel informed about these guardrails that are out there, know that they exist and what's applicable specifically to charities. In this case, I know everyone in the audience might not be in the charitable space, but to also identify some of the opportunities around reasonable compensation, around tying your compensation structure to the charitable purposes that the organization is carrying out, and that the definition of charitable can change over time. So I hope I've left with a little bit of hope on that side of things. I want to turn things over to Tia. And I'm happy, like Kiki, I'm perfectly happy to answer additional questions offline, not as your attorney, but with educational purposes in mind. So I'm gonna leave my email in the chat also, and happy to talk with folks. So thanks, Tia.
Awesome. Thank you everyone for presenting. I just wanted to do the last call to action before opening it up to Q&A for a few minutes. That this event was part of Co-op-A-Looza Week, where we're trying to raise $20,000 for our workplace democracy work. I'm going to put, somebody already put in the chat the fundraiser link. Please donate if you can, or if you haven't yet. And my coworker, Wanda, who's been doing tech support, thank you so much, Wanda, has sent us some questions from the chat. One was, I'm going to stop sharing my screen. One was, could you say more about what it means that it's a one-time adjustment? And I think that was in regards to the reparations adjustment, Alejandra. Was there a reason why it was just a one-time adjustment?
Yeah, I think initially we thought that a one-time adjustment would put us in a better legal position, but I don't believe that ended up being true. The other things that we wanted to leave space for was feedback from coworkers. We did a survey and just to see how it felt to opt in or opt out and to receive the money before we automatically applied the adjustment in future years. We also wanted to allow time for further legal research, weighing risk, and also to consider the other options that were out there.
Thank you, Alejandra. Another question was how to adjust for someone who may be supporting a partner with invisible disabilities that affect their income or ability to work full-time, but aren't bad enough to receive federal or state disability. So in our needs-based calculator at the Law Center, we don't define dependents very strictly. We just say anyone who you want to consider your dependent if they rely on you for a big amount of their income, then you can consider them your dependent. So we don't ask anyone for proof that they have a disability or that they're, I guess the only proof we do ask is that we ask how much they make, and if in disability payments, or like my mom has disability payments, I claim her as a dependent. And so she gets, I don't remember, like $1,300 a month that gets subtracted from my bonus. So I get a smaller amount to support her. And that's how that works. But if she didn't get those payments, then I think I might get even more because she would have no income at all if it weren't for from that help from the government.
I might have one more question that I found. I'm not quite sure if it was addressed in the chat, so I'm just gonna drop it again. There's that question.
Does legal risk extend beyond the risk of an individual employee making a suit or claim? Like, could the local, state, Fed government intervene if they suspected an employer's pay policy to, hold on, where'd it go? To be unfair or illegal? Or could a conservative or any policy or law center intervene or sue? And I see.
So this is Kiki speaking, because I don't think I'm spotlighted, but yeah, so I did answer this in the chat, but it's an interesting question, so I don't mind answering it again quickly. But yeah, so it is not uncommon for either a state attorney, like a city attorney or the attorney general of a given state to intervene on behalf of a state for especially wage theft claims. It's a really big thing that happens in Colorado, especially in the marijuana industry, actually. And with migrant farm workers, actually, is becoming an increasing thing. But also the EEOC does bring, it's not a technical class action lawsuit like you would see under Rule 23 of the Federal Civil Rules of Procedure. It's a different type that they're enabled to do under Title VII. And a lot of times those stem from a single complaint. And that's a lot of the cases that you'll actually see from the EEOC. And what I said in my answer is there was actually a big one in the Mountain West in, I think it started in Colorado, where basically they found that Dillard's was systemically discriminating against people of color who were seeking management positions. And it started with a single complaint, spiraled out into a huge class action lawsuit against almost all Dillard's. And now the entire corporation of Dillard's is subject to this consent decree that came out of this case. So it is not uncommon for that to happen on behalf of the federal government because they have jurisdiction to do that through the EEOC. As far as private actors, the answer generally is no. In order to bring a lawsuit on behalf of anybody, you have to have standing, you have to show that you were personally injured. So it's very unlikely that they would be able to show if it was some conservative think tank or nonprofit or something that they're subject to, or that they've been harmed because of something that some individual employee has been sued for, if that makes sense. This is also very offhandedly why SB 8 in Texas is so illegal beyond not having any basis in reality for Roe v. Wade, and also just nobody has standing to bring lawsuits about abortion care. But that's a one-off about reproductive rights that I felt the need to sneak in there. I hope that answers the question.
Thank you, Kiki. And yes, all of these issues are interconnected. We're trying to win them all. So thank you for bringing that too. And we only have 1 minute left. So if we didn't answer any of the questions in the chat, I will try to pull them out in an email and send some kind of follow-up. Either it might be an answer if it was simple enough for me to answer, or it might just be an invitation to come to our legal cafes where you can get 30 to 45 minutes with a volunteer attorney to answer questions about employment law and civil rights law and nonprofit law, all of the things that we went over today. But thank you all so much. We are going to end exactly on time because we have another event starting in 15 minutes. It's the Immigrant Rights and Worker Cooperatives MCLE. So if you want to join that, join us in 15 minutes. Thank you all so much for presenting and for attending and for donating. Thank you to our ASL interpreters. And I hope you all have a good day. Bye.